What is the least restrictive environment for a qualifying child? Let's break this question down into two different parts. First, let's learn what it means to be a qualifying child. A qualifying child is essentially a child with a disability. To be considered as a child with a disability, one must be diagnosed with any one of the following: intellectual disability, visual impairment, hearing impairment, speech or language impairment, emotional disturbance, orthopedic impairment, autism, traumatic brain injury, other health impairments, or specific learning disability. One must also need special education as a result of their disability. Simply having a disability does not sufficiently qualify someone for special education. There must be a need for such services in order to qualify under the Individuals with Disabilities Education Act, or the IDEA. Now let's take a look at the other part of the question. What is the least restrictive environment, or the LRE? The IDEA defines least restrictive environment as, to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are not disabled. In special classes, separate schooling, or other removal of children with disabilities from the regular education environment occurs only when the nature or severity of the disability of a child is such that the education in a regular class with the use of supplementary aids and services cannot be achieved satisfactorily. What exactly does all of this mean? What this means is that a child who has been deemed as a child with a disability and is therefore qualified for special education under the IDEA is to be educated in the environment that is best suited for their needs, without causing any unneeded restrictions on that child. The concept of least restrictive environment, although seemingly straightforward, is actually quite vague and open to different interpretations. In the journal article, An Analysis of Legal Issues Relating to the Least Restrictive Environment Standards, the author states that the ambiguity of the least restrictive environment mandate has caused issues nationwide because of the many ways it can be interpreted. He deduces that this has led to more court cases whose verdicts actually end up clearing up parts of the LRE mandate. One of the many court cases he discusses in this case study includes the tale of Daniel R.R. and his battle with the State Board of Education in 1989. Daniel was a 6-year-old boy with Down syndrome who spent half of his day in a regular education kindergarten classroom and the other half of his day in a special education classroom. His IEP team took him out of the regular education class because he was not making significant progress. They placed him in the special education room for the whole day, except for during lunchtime, which was the only part of the day he spent with general education students. His parents were not very happy about the change and took the dispute up to the U.S. Court of Appeals in the Fifth Circuit. The court used two tests to decide the outcome of the dispute, the same two tests that are used in later court cases, such as KB v. Nebo School District in 2002. For the first test, the court asked the district if supplementary aids and services could be adequately provided in a regular education classroom, which could lead to success in Daniel's education. This led to an investigation into whether the school provided adequate accommodations, like modifying the curriculum and providing enough assistance to students with disabilities in regular education classrooms. For the second test, the court asked if Daniel was still given the absolute best chance for integration while in a separate classroom. The court decided that Daniel's school had not satisfied the least restrictive environment mandate of the IDEA. Alcranie argues that the tests used in this court case, accompanied by the tests used in other court cases, help enumerate specifics about the least restrictive environment requirement that are otherwise vague and open for interpretation. He suggests that educators use previous court decisions as general guidelines when trying to place a student in his or her least restrictive environment. One thing we need to remember when placing a student in their least restrictive environment are the differences between least restrictive environment and mainstreaming and inclusion. Some people will even substitute these three terms for each other. This is incorrect. A good rule of thumb to remember is that the least restrictive environment is not always in a regular education classroom. It can range anywhere from a regular education room to a hospital bed. Mainstreaming and inclusion are when students with disabilities are educated alongside their non-disabled peers. This is just a small portion of everything that the least restrictive environment mandate entails. Placing students in their least restrictive environment is a difficult and daunting task for us educators. We are given a rule that's necessary to follow, that every child must be educated in the best possible setting. This sounds smart and reasonable, so we go about trying to do this in the best possible way. The difficulty arises when we are required to define and personalize an immensely broad mandate, not just one time, but for every student that comes to us seeking help. By looking to the past and learning from the mistakes that have already been made, we can hopefully seek out a brighter future for those students who are placed under our care.